Supposing you are going to buy a property or to sell a property, is it advisable to register the sale agreement? Supposing you are a buyer, is it advisable to go for a registration of a sale deed? What are the advantages? What are the disadvantages to a buyer in the registration of the sale deed, sale agreement? Similarly, suppose you are a seller, is it advisable to go for a registration of a sale agreement? What are the advantages? What are the disadvantages? What are the consequences which may arise after the registration of the sale agreement? Let us discuss all these things in this video. Ladies and gentlemen, I am Raziaq Lawtube. I welcome all to my channel. Previously, the registration of the sale agreement is not a compulsory thing. When you are going to buy a property, you will have to register the sale deed. The registration of the sale deed alone is made a compulsory one. Now, the latest laws made the registration sale agreement also included, and so the sale agreement should also be registered through a registered document at the registrar office. So they made it as a compulsory one. Now there are a lot of consequences, lot of problems, lot of issues, lot of doubts arises out of this things. So many people ask the question, sir, shall we go for a registration of a sale agreement? What are the consequences? What will be the things which may happen because of this registration? So too many questions are raised. There are instances where the people got stuck because of the registration of the sale agreement. What happens? Supposing you are a owner and you wanted to sell a property for your urgent need. For example, suppose you need a money for your medical surgery, or suppose you need money immediately for your daughter's marriage or for your children's education. You may come forward to sell your property, and at that time you may insist the buyer to, you may try to get a buyer who is ready to buy the property in a short time. So when under this circumstances, some of the real estate brokers, mediators, they used to come and approach you, and they will say, I am ready to buy the property for a lesser price. They may offer to buy the property for 50% of the original price, and they may say, give an assurance that they will finish the deal within a week or within 15 days or within a month. Like that, they may give a false assurance, and under the text, they insist you to register a sale agreement and pay a small amount of 1 lakh as advance, and they will promise you to pay the balance within a week or within 10 days or within a short period at the time of registration. After that, after registration of the sale agreement, if they didn't turn up, and supposing some other buyer come forward to buy the property to a higher price, and if you approach the registrar office to sell the property to the subsequent buyer, the registrar will not permit you to register the sale deed to the subsequent person. They will insist. There is already an agreement, registered agreement is there, registered at the registrar office. The incorporate certificate shows the sale agreement registration. So during the existence of this sale agreement, you cannot register a sale deed to any other person. Like what they may say, and they may refuse to register a sale deed to subsequent purchase. Under this circumstance, if you approach the agreement holder first buyer and say, supposing they have agreed to purchase the property for 10 lakhs, now you got a buyer for 20 lakhs. And if you approach the buyer to come and cancel the sale agreement, then he will say, this 10 lakhs additional benefit should be paid to me. You pay me 10 lakhs, I will come and cancel the registration, like what they may demand. This is the things happening in the present sceneries. So how to avoid these things? So supposing you are a buyer and you wanted to sell the property immediately and you want to fulfill your immediate requirement, it is not advisable to go for a sale agreement. And if you are in urgent need of money, you may directly say the buyer to register the sale deed directly without going for a sale agreement. As far as the law is concerned, the law says that if you are making a sale agreement, it is to be registered. If you are not making a sale agreement, then you need not go for a registration. So the law does not say that for every sale there must be a sale agreement. The law does not say like that. If you are going for a sale, you can directly sell the property through sale deed. Supposing you want to make a sale agreement, then it is to be registered, like what the law says. So supposing you are a seller and you need money immediately, you may avoid the registration of the sale agreement. That is the best option to the seller. Now the question will arise. Suppose a genuine buyer approaches you to buy the property and they wanted to go for a bank loan. Then the bank will insist to produce the sale agreement, without which they will not release the loan amount. So what should we do? We should complete our task, but at the same time we should also safeguard our interest. Both the things are important to us. So in that case, you will have to see whether the proposed purchaser is a genuine purchaser, he is purchasing the property for himself, or if he is just a mediator, a real estate broker, and he just wanted to buy and sell it to another person for a big money. So you will have to verify the things. If you are satisfied that the purchaser who is going to come and purchase the property is a genuine buyer, then you can show the documents and you can produce the document to the bank and you can verify all the details, all his preparedness. After that, once everything is finalized and once the bank also prepared to give the loan, that fact is also confirmed, then you can make a sale agreement. Now, as far as the bank is concerned, they are releasing the loan amount even without the registered sale agreement. In practice, most of the banks are simply saying that before releasing the payment amount, they are simply asking one document that it will be a unregistered sale agreement. Like once an unregistered sale agreement is produced, they are on the basis of that. They have prepared the check and they will issue the check only at the time of registration of sale. They will not issue the loan amount on the basis of the sale agreement or anything. They will not release any loan prior to the registration of sale deed. So in that way, you can safeguard your interest. In some cases, what happened now? The property they will be selling the property for 1 crore. And actually, they may go for the guideline value or the registrar value may be around 60 lakhs. In that case, some of the mediators are tempting the insisting the seller to enter a sale agreement for a lesser price. They will misrepresent as if you put original price, then you will have to go and register the sell lead original rate. That way you will have to purchaser will lose stamp duty, registration charges and extra amount, and you will also face some income tax problem like that. They may insist, and they are insisting the buyer to register a sale agreement for a lesser price. If the deal is went genuinely, then no problem. Supposing they make actually you have agreed for a 1 crore, and if they have made a sale agreement for 60 lakhs and he did not pay the actual 1 crore as orally agreed or orally understood as per the understanding you reached, and they go to the court and file a case saying that I am ready to purchase the property, we have entered a sale agreement to purchase the property at the price of 60 lakhs. Now the seller is refusing. So we request the court to pass an order to sell the property at the price of 60 lakhs. Then you will be in trouble. Then you will be losing the balance amount. So how to tackle these things? The best idea is, if you are a buyer, if you are a seller, you may avoid the registration of the sale agreement. You can insist the parties to register the sale deed directly, and you can collect the entire amount at the time of registration of the sale deed. But for a genuine cases, suppose genuine buyers are approaching you and they are coming forward to purchase the property for their own use, that time also you may delay the registration of the execution of the sale agreement. You can hand out the papers, you can share the papers, you can share the documents. They may forward the documents to the bank and they may get the sanction order. Once everything is ready and the bank is prepared to release the check amount, that time you may make a formal sale agreement, unregistered sale agreement. Now they are accepting such type of unregistered sale agreement, and today you may register a sale agreement. Today you may execute a sale agreement. Tomorrow you can have the registration, or you can have the both sale agreement and sale deed simultaneously. You can produce the sale agreement on the date of registration. They will bring the check, and immediately on the next day, on the same day, you can have the sale deed registration. They will hand over the check to you. So both of you will be in safe. So like that you can make necessary arrangement to safeguard your interest. As far as the buyer is concerned, sale agreement, making a sale agreement will safeguard their interest for the proof of payment, for the proof of arrangement they have as agreed. If you are a genuine buyer, you can convince the seller saying that we are going to purchase this property for our for your own purpose. We are not a mediator. We will not cheat you in any way. And you may also postpone. If you are going for a loan, in that case you may be requiring a sale agreement for the release of the loan amount. Or otherwise, there is not. If you are paying the amount from your if you are paying the entire amount from your own funds, then in that case, sale agreement is also not necessary. But if you are making any payments, then for that payment you will have to get sale agreement or at least sale receipts or some type of receipt to confirm that you have paid this amount towards the part satisfaction or towards the advance for the purchase of this property. So one more question is also arises. Previously, what we don't know, when we are making a sale agreement, we will quote the original price. Supposing they are actually A and B are agreeing to sell the property for 1 crore. Previously, they used to put 1 crore as a sale price in the sale agreement. Once they go to register office, supposing the registrar guideline value is less than the agreed price, then the party will try to to avoid unnecessary expenses or to avoid the stamp duty, they used to quote lesser price, say 60 lakhs, and they used to pay the stamp duty and registration charges for the 60 lakhs, and the remaining amount is being transferred as a black money. Such type of things has happened in the previously. Now also, if you are going directly for a registration or sale deed, that time also the same things happens. Supposing the property is sold for 1 crore, and you are going only, as per the registrar value is only say about 60 lakhs, then the 60 lakhs money is mentioned in the sale deed, and the remaining amount is transferred from the purchaser to seller as a black money. Now, whether you are a purchaser or whether you are a seller, as far as the sale transaction is concerned, we will treat as if we are walking in a row. Anytime it may go this way or that way, it may go break. There may be a breakup at any time. So we will have to be careful on each and every stage. When you are purchasing the property, if you want to purchase the property, you will have to peruse all the title deeds, encumbrance certificate, possession. And when you are making payment, you will have to get proper receipts. If it is possible, you will have to make transfer through checks, DD. And you should also see that whether the particular owner is the real owner and whether he has the original documents with him, whether there are any litigations, whether it's encumbrances, whether it is a bank loan, etc. All these things you will have to see. In addition to that, you should also see the characteristic features of the buyer and seller before entering into any sale transaction. I hope this message is useful to the buyer and seller. There are 2 channels, large channels, Raziaq Sattamarivom and Raziaq Lawtube. One is in English, one is in Tamil. You may watch my channels and you may clear your doubts and you may also enrich your legal knowledge. In addition to that, if you have any specific doubt, clarification, or if you require any consultation, you may contact this number. If the time so permits, I will give you proper guidance or consultation. With this, I conclude this video. Thank you for watching this video. Goodbye. Raziaq Ali.